Hi, everyone. Welcome to Crime in Court. This is another episode of the Canton cover up series, Commonwealth versus Karen Reed. This is episode 119. We are titled Bederow Sanctions and Correcting the Record, and we are going to be talking about multiple filings that just came out at basically at the end of the day on Friday. So at on Friday, I had recorded because I think also on Friday there was a supplemental filing for from the defense, a supplemental filing for Mark Bederow because Judge Bev had requested that. Because if you recall, a couple hearings ago, they wanted to argue their motion to bring Bederow on, and Hank Brennan stood up and said, I don't object, but then went on for about 20 minutes as to why he objected to Mark Bederow joining the team. If you don't know, Mark Bederow, he's kind of LawTube famous. He's kind of joined the LawTube conversation with the Karen Reed case, catching his attention, and he's been on a lot of different YouTubers' shows and whatnot. Um, but through that, Turtle Boy and he connected, and now he represents Turtle Boy with Aiden Carney's witness intimidation charges. So he's got multiple witness intimidation charges. He also has Tim Bradle on his team. Mark Bederow joined recently to Turtle Boy's team. So there could be a conflict of interest between Karen Reed and Turtle Boy. However, they both have like the same common goal, which is to expose the corruption, and, they're in the fight for their lives because the entire power of the state is coming after them both. So they're trying to fight against that and expose the corruption and try to affect change, rather, because I mean, the system is broken, as you can see, in at least definitely in Massachusetts. So let me shrink myself. Let's get started here. As we were talking about Bederow, so I had scheduled that video, and then no sooner than I did, this decision came out about Bederow's pro hoc vice status, and it's not good news because Judge Bev she's gonna Bev. So, um, here is this motion. Please hit that like button before I forget to remind you guys, and make sure you are subscribed because we do go over all of the court documents here on this channel individually and break them down. All right, so this is the decision and order on defendant's supplemental motion for admission pro hoc vice of Mark A. Bederow. After review of the pleadings, the defendant's supplemental motion for pro hoc vice of attorney Mark A. Bederow is denied. This is kind of unprecedented. A lot of legal anal- a- legal analysts, lawyers and people on LawTube who have been um, talking about this case have all said that this is pretty much an unprecedented ruling. This they never see. People don't usually get denied their pro hoc vice status, especially a lawyer in good standing. And we read through the supplemental affidavit. He's able to practice in not only two districts of New York, but also I think Jersey, a bunch of different states. And it's not just Massachusetts. He's also, you know, admitted as pro hoc vice status with Turtle Boy. So he's already admitted in Norfolk County, but Judge Bev was like, nah, that doesn't matter to me. I don't care. I don't know what they can do. A lot of law tubers are saying this isn't really appealable, although it is a federal constitutional right that you have the right to counsel of your choice. So for her to deny counsel counsel of Karen Reed's choice, this could be appealable. I think, but a lot of people have suggested it's not going to go anywhere, which I think is ridiculous because this is violating her constitutional rights again. So double rights, double jeopardy rights out the window. Her right to counsel of her choice out the window. What else? I mean, the list goes on, but we'll stop there. All right, so the affirmation submitted in support of the motion is insufficient on its face. How? I don't know, because they provided everything that she wanted, everything that was of concern. And by the way, any conflict of interest that existed would be between Karen Reed and Turtle Boy, and they both have waived it. Like literally, on paper in an affidavit, waived this conflict of interest. But Bev doesn't care. She says, in addition, the proposed concurrent representation involves a conflict of interest, see, that is not waivable. Who says? It's absolutely waivable, and it was waived. But she's just like making the law and saying, nope, it's not waivable under Massachusetts rules of professional responsibility. So now she's kind of like, now she's going to go into impugning Bederow's character and even kind of Yannetti, and how Bederow might be leaking things from one team to another. I mean, basically, she's throwing his ethics into question and his reliability, which is such garbage. Like, this filing makes me very angry. So, one such conflict is specifically outlined in the motion at paragraph 8, where Mr. Bederow, apparently speaking through Mr. Yannetti, so she's mad here. She's saying, apparently speaking through Yannetti, like Bederow couldn't file his own? Well, no, he can't file his own paperwork because he's not admitted as an attorney in the case. So she's kind of like trapping him, like he can't win either way. So she says in paragraph 8, where Mr. Bederow, speaking through Mr. Yannetti, promises to restrict his use of certain information, the clear influence of the promise, or inference of the promise. So just the fact that Mr. Bederow had to make this promise is that Mr. Bederow would not use protected information gained in the representation of one client for purposes of his representation of the other client. He thus proposes to ignore information known to him through his representation of one client where the information might benefit his second client. So, like if somebody, this isn't going to happen, but let's say Karen said, yeah, I hit him to uh well, no, that wouldn't make sense. Let's say Turtle Boy admitted to witness intimidation. So basically, yeah, she's protecting Turtle Boy. So she's saying if Turtle Boy were to admit to Bederow that he really did commit witness intimidation, then Bederow would not disclose that because it would not benefit his client to disclose it. I think that's what she's getting at, but also calling into question his ethical oath, his ethical duty as an attorney. So she's not having it. She says he proposes to ignore the information known to him, even when the information might benefit his other client. The court cannot permit such conflicted representation and declines to add to the defense team that currently numbers at least 4 lawyers, 3 by admission pro hoc vice. So now she has a problem with the number of pro hoc vice attorneys that Karen Reed has. And by the way, there is no limit. There's no limit to attorneys you can have, especially if you're paying for them or they're representing you uh, uh, pro bono. I couldn't think of the word. But there's no limit. I've even looked, the Constitution says there is no limit to the number of attorneys that you can have if you're paying for your own. If you are, not indigent and you are providing your own defense team, there's no limit. So this Pro Hoc VJ, I don't want to admit another Pro Hoc VJ, blah, blah, blah. She is such a bitch. I'm sorry, but she is. All right, so defendant's supplemental motion for admission pro hoc vice of Mark Bederow is hereby denied. She could not wait to deny this because no sooner than they had basically filed it, she denied it. So there's that. She also, this on top of the recent filing that we also went over, which was the Dr. Crosby, she's allowing him to come in. Dr. Crosby is a dog trainer, and she's going to allow him to come in and testify to the medical causation of wounds to John's arm. And he also has a mold of Chloe's teeth, of supposedly Chloe. We don't know if it is Chloe. I think Chloe's no longer with us in the physical world, because she's evidence. And I think that Brian Albert was good at covering his tracks and calling in his favors. So he made sure that Chloe was gone, basement was gone, everything was gone, car, whatever, house was gone. He did it all. So, anywho, all right. So, yeah, so James Crosby and this particular ruling, all the law tubers are saying Judge Bev is biased. And I've been saying that from the beginning. I think she's corrupt, to be quite honest, beyond bias. This is beyond judicial discretion. This is judicial corruption, in my opinion. But that is, I could talk about Judge Bev for days. God, I hate her. But I won't make you suffer through that. All right, so the Commonwealth's motion to correct the record. Well, what is this about? So Hank lied yet again in open court. He said that David Yannetti was making some extrajudicial statements about the federal investigation into the death of John O'Keefe. And so what he did, there was a Zoom hearing. So this was a hearing in front of the court, in front of Judge Bev, where it was on Zoom. David Yannetti and Karen Reed were side by side on a split screen, and you can hear David Yannetti talking about the federal investigation. This is an open court. This is part of his work. This is part of his, he's under oath, he's in open court. So, and these are the things that, he's protected by, like, work. So I don't know what I'm trying to say, but I hope you guys do. Anyways, he can say certain things in court, whereas if you say something outside of court, it's an extrajudicial statement, and you're not supposed to be doing that ethically as a lawyer. So what happened was Brennan was like, oh, well, he's making these extrajudicial statements because he saw a court TV clip or a court TV, news segment where they took portions of this Zoom hearing where David Yannetti was talking about the federal investigation, and they played it on court TV. And he probably mistook it as like, this is Vinnie Politan interviewing David Yannetti and Karen Reed. Or, I'm giving him the benefit of the doubt and saying maybe he did screw up and think that, but I don't really think he thinks that. I think he always knew that he was lying in open court, but he had to correct the record. He didn't do it in open court, so he had to do it in a filing, and that is what we have, which is so embarrassing. But here we go. So this is now comes Hank Brennan, special prosecutor in the above docketed case, and submits the following affidavit to correct the record relative to the March 5th, 2025 court hearing. And here is his affidavit to correct the record. My name is Hank Brennan. It doesn't say. He actually spelled it right this time. My name is Hank Brennan. I have been appointed special prosecutor assigned as lead counsel for the case of Commonwealth versus Karen Reed. In oral argument, I provided a number of examples of extrajudicial statements, a number of examples that have been made by defense counsel, as well as examples of our court statements made relative to the now closed federal investigation and the potential impact such statements may have on the potential jury pool. One of the examples that I cited to support commentary about the now closed federal investigation, which I don't think it's really closed, I think that was all a PR ploy. The now closed federal investigation was a statement made by Attorney Yannetti. I inadvertently and mistakenly characterized one of his statements as an extrajudicial statement. The statement by Yannetti was not an extrajudicial statement. It was a statement made during a Zoom hearing in the Reed case. The statement was aired as part of a segment posted by Court TV entitled Karen Reed's Attorney Talks Federal Investigation with Court TV. Oh, so he's blaming Court TV because of the way they titled it. Uh-huh. The segment included a story regarding the case. Well, did you watch the whole thing? Because if you did, then you would know that it was actually a segment where they were taking clips of a Zoom hearing. But if you didn't watch the whole clip, then you shouldn't be filing for, or you shouldn't be making these you shouldn't be making these statements in open court, lying about things that are being said, what you think, outside of court by David Yannetti, when you're wrong because you didn't do your research. You didn't verify. The 4121 segment, hold on. Sorry, my dog. All right, so the 4121 segment video includes a Court TV anchor story on the case, witness interviews, and includes some clips from court hearing coverage, including a Zoom court hearing. The quote from Attorney Yannetti was from a statement Mr. Yannetti made during a Zoom court proceeding in the Reed case. I mistakenly stated that Attorney Yannetti's statement was an extrajudicial statement. My mistake was unintentional and regrettable. Signed, Hanky Brennan. So there's that. He had to correct the record, which glad he did, but still shouldn't have said it in the first place. This one, he wants to extend his deadline for his motion in limine. If you recall, there was at the end of, I think it might have been the last hearing, I can't remember. They were talking deadlines, and Attorney Brennan was like, "Oh, can I have till Monday to do my motion in limine?" And she was like, "Oh yeah, sure, Brennan, whatever you want." And then that was a terrible impression of Auntie Beth. But then Karen Reed's attorney, Liza Little, stood up and was like, "Hey, I would like to be granted that same courtesy and have till Monday to do our motions in limine," which is basically a motion to either talk about, what evidence comes in, what evidence comes out. You can have things excluded or included, whatever, you feel is important to your case, and then you argue why it should come in or shouldn't come in, and then the judge ultimately rules. So that's where we're at for the motion in limine. He wants more time. He also spelled reciprocal wrong, as people have noted. And he spells things wrong often, and he doesn't, even his own name, and he doesn't proof. But we will continue. So this is his motion for extension of time to file motions in limine related to the defense expert reciprocal discovery. Now comes the Commonwealth in the above captioned matter and respectfully moves this honorable court grant the Commonwealth an extension to file motions in limine related to expert witnesses. So this is just regarding experts. He says the defense provided notice of 12 defense experts. We don't know who all 12 are. We have some guesses of who some are, like Dr. Marie Russell, the ARCA experts, people like that. Richard Green, who found How Long to Die in Cold on John McCabe's phone extraction, and is the only one that testified correctly and honestly about it. Um, so those are just some of the experts. We don't know who all of them are, but it sounds promising that they are coming, locked and loaded for trial number 2. They are ready to put on a much more comprehensive defense. Last time, I believe they got overconfident with how insane the case was and how, if anybody watching from home understood the case, and we all, commented on it later and knew that the Commonwealth was crooked as hell and all the Commonwealth's witnesses were lying. So it seemed pretty obvious to people that Karen was going home, but we underestimated the evil of Judge Bev, John Fanning, and others that might have played a role in, I don't know, putting plants in the jury or even, you know, filing false reports or making false reports to John Fanning to get people kicked off the jury who seemed to have been pro Karen Reed and someone who, this is interesting. I heard on the Turtle Boy show that one of the jurors who got kicked off because of the John Fanning thing, I think it's that one, or one of the ones that became an alternate, has some things to say and said that she in fact put in her notebook that all these people are lying. So could it be that somebody was going through their notebooks? It would be very interesting to find out if, some of these people in charge of the jury from trial 1 would be brought up to testify. But that's never going to happen in Bev's courtroom, but it would sure be interesting. All right, so the Commonwealth moves. Oh, they got 12 new defense experts and partial expert disclosures March 26th or March 6th. So just this past week, they had to disclose their reciprocal discovery to the prosecution, and which, you know, they're on time. It's not late. It's not anything wrong with them turning this over, but the Commonwealth is now saying, well, we need an extension. We don't have enough time because they probably want a Daubert Lanigan hearing for every single one of their experts that they've tried to do, as you've seen. So, and Judge Bev still has not ruled on the ARCA experts, which that needs to get ruled on, and they need to come in. All right, so the Commonwealth moves for an extension of time to permit the Commonwealth an adequate opportunity to review the defense experts' reports to prepare many appropriate motions in limine. So they want to exclude a bunch of experts is basically what they're like. Be prepared. We're already going to try to get these experts excluded. The Commonwealth requests until March 14th, 2025 to file motions in limine regarding the expert disclosures that the Commonwealth received on March 6th. Furthermore, the Commonwealth has not received further disclosures relative to the ARCA witnesses. You're not going to get any. That's all you're getting from the AG's office, so shut it, Hank. Nor has the Commonwealth received reports or anything besides a CV for 2 noticed experts. For those witnesses, the Commonwealth reserves their right to file motions in limine at a time after the required disclosures have been provided. The Commonwealth anticipates filing all other motions in limine on Monday, March 10th, 2025. So any other motions in limine that they wanted will be filed tomorrow, March 10th. However, they want to be able to reserve their deadline or extend their deadline for the expert witnesses. So we should be seeing some motions in limine tomorrow from both sides. So that'll be some interesting reads. All right, finally, this one is the kicker. So, memorandum of decision and order on Commonwealth's motion to impose sanctions pursuant to Mass R. Crim. P. 48, an oral motion to prohibit prejudicial extrajudicial statements of counsel. A long title. On June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of homicide in the second degree, manslaughter while operating under the influence of alcohol and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe, on January 29th, 2022. Trial on the matter began in April 2024 and concluded on July 1st, 2024 with a mistrial. The matter is set for retrial April 1st of this year. There have been more than 500 filings in this case, many of which are subject to protective orders. The case has generated significant media attention locally and nationally, with the defendant and defense counsel participating in numerous interviews with media outlets. So what? It's not illegal. In addition, the court is aware that there was also a federal investigation into the investigation of O'Keefe's death. Recently, the Commonwealth represented in open court that the federal investigation has concluded, but we have not seen anything. And without any issuance of indictment. So not only has it concluded, but nobody's going to jail. This sounds so fake. A federal agency is never going to tell you that their investigation's over. This is unbelievable. And the fact that she just takes him at his word, like, that's insane. But everything that the defense says is she questions. It's ridiculous. Before the court are two motions: the Commonwealth's motion to impose sanctions and an oral motion made by the Commonwealth to the court on March 4th, 2025, renewing its prior written motion seeking to prohibit extrajudicial statements or gag order of counsel that would have a substantial likelihood of materially prejudicing these criminal proceedings. For the reasons that follow, the court will deny the Commonwealth's motion for sanctions. So they're not going to have sanctions. This doesn't have to do with Jackson being kicked off the team either. This is completely separate. This was Hank wanting sanctions on the defense team because they put in like a text message from Proctor about Jackson that was protected or under a protective order or something. So, anyways, so she's denying that motion for sanctions, but she's allowing the Commonwealth's motion for an order limiting extrajudicial statements of counsel, or basically, she's imposing a gag order. So, discussion: Commonwealth's motion to impose sanctions pursuant to Mass R. Crim. P. 48. Pursuant to Mass R. Crim. P. 48, a willful violation by counsel of the provisions of the rules of criminal procedure or of an order issued pursuant to these rules shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt or the imposition of costs or a fine. The purpose of the Rule 48 is to allow judges to regulate the conduct of attorneys who practice in courts of the Commonwealth and to discipline those whose actions fall short of accepted standards. Reporter's notes to Master Crim. P. 48. In addition to the sanctions of citations for contempt and the imposition of costs or a fine, the rule contemplates referral to the Board of Bar Overseers where appropriate. So, if you get out of line, I can send you to the Board of Bar Overseers. Where's the Board of Judge Overseers? We need one of those for Bev. What the hell, man? The Commonwealth's motion for sanctions is in response to the defendant's motion to reconsider reciprocal discovery order. Did he spell it right that time? It looks like it. All right, so wherein Defense counsel quoted information subject to protective orders issued in this court by November 13th and January 31st, 2025. Attorney Yannetti has acknowledged that this motion, which was not protected from public view, should not have been included protected information. However, he represents that the inclusion of protected information was a mistake and not a willful act. As a sanction for this conduct, the Commonwealth requests that this court issue an order for the defense that they file all motions under seal and impoundment until such time that both the Commonwealth and the court can ensure that the filings comply with all previous orders set by this court. So the prosecution wanted all filings to be filed under seal, impounded, and with the ability for the Commonwealth and the court to review them before making them public. That's what they wanted. Yes, the sanction sought by the Commonwealth is not appropriate. Thank God she actually did something judgy, something right. Rule 48 allows for the imposition of punitive sanctions on individual attorneys who intentionally violate the rules of criminal procedure or the court's orders. Sanctions that may be imposed include a citation for contempt or the imposition of costs or a fine or referral of the matter to the Board of Bar Overseers. Although procedural remedies such as the initial impoundment of documents sought here are available under other rules of the court, see Uniform Rules of Impoundment Procedure, Trial Court Rule 8, Defense Counsel has assured the court that it will take more care in the future with protected information in court filings. The court therefore declines to impose any sanction under Rule 48 at this time. However, subsequent and/or repeated violations of court orders may well be considered either willful conduct or careless inference that warrants sanctions by the court as permitted by the rules. So if you keep it up, I will sanction you. Commonwealth's motion to prohibit extrajudicial statements of counsel. Few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right. Thus, restraints on extrajudicial statements by counsel may be warranted in a particular case to protect the integrity and fairness of the judicial system. But it's okay for the state to leak stuff to media and make people spin certain things a certain way so that it sounds like the defense is guilty. Like, for instance, when one of the news outlets decided that they were going to immediately report that there was ring camera of Karen actually mowing John down with her car. This was not true, never verified, but yet they ran with it in the very beginning, and that made a lot of people think that Karen Reed was guilty. So if you want to talk about tainting the jury, let's talk about that. Let's talk about the things that the Commonwealth is leaking to the media at this time. Because and not just the media, but like influencers like Jennifer Coffindaffer and other people that, hate Turtle Boy that want to be on the internet and trolling people all day. It's happens all the time. I just block them. But actually, it is kind of fun to like give them shit. So I've been kind of enjoying that. But anyway, yes. So the trolls, the internet, influencers that the Commonwealth has legitimately hired. They have hired Jennifer Coffindaffer, who's former FBI, to spin their narrative. We have not leaked, but FOIA requests that basically have shown that, and she's working for them. All right, so thus restraints of extrajudicial state. Oh, I read that one. Let me just scroll down. Lawyers in pending cases may be subject to ethical restrictions on speech to which an ordinary citizen would not be. So ordinary citizens like you and I can talk about this case and say these things, like a Jennifer Coffendiver. She can talk about it because she's not actually employed by anyone at this time. So she can talk about whatever she wants, spinning the state's narrative. Yet the defense counsel is basically they have their hands tied and they're not allowed to talk or, you know, um, I'm sure they're not allowed to leak things either at this point. So, all right. So how, well, they're not allowed to leak things, but uh, private things, protected things. However, the regulation of attorneys' speech is limited. It applies only to speech that is substantially likely to have a materially prejudicial, big words, hard to say. The regulation of attorneys' speech is limited. It applies only to speech that is substantially likely to have a material prejudicial effect. Consistent with these principles, a court may issue a gag order, which restrains the speech of participants in the proceeding if the order is justified by a compelling state interest to protect against a serious threat of harm and is no greater than is necessary to protect the compelling interest. Such an order may be supported by detailed findings of fact that A. Identify a compelling interest that the restraint will serve, and B. Demonstrate that no reasonable, less restrictive alternative to the order is available. So there's no other alternative that's less restrictive than a gag order, is what she's saying, which I find disingenuous because for the first trial, Adam Lawley tried to tried to get a gag order on the defense, and he was denied. So now, for some reason, she's like, "Yeah, sure, cool. It's the only way. It's the only thing I can do. There's no other less restrictive alternative than a gag order." I'm not like totally infuriated by this because at this point, like they've already gotten their word out. They've already, at this point, a lot of people already know who Karen Reed is, and she's got a lot of justice warriors like us spreading the word. So that part I don't care so much about because the trial's only a few days, only 22 days away. I think we're at 22. And yeah, so at this point, we already pretty much know, and everything else is going to be done in court filings. So I'm not too like bummed about a gag order. I'm actually kind of happy that they can't be going on on news stations and doing interviews anymore because not that I want them to be gagged, but I don't want them to keep coming at them for the interviewers' notes and things. So it's kind of better for them not to be doing these interviews. The Commonwealth seeks a gag order to prevent defense counsel from making extrajudicial statements in violation of the rules. Well, what about, she's saying it to prevent defense counsel? What about the prosecution? They've lied in open court multiple times, had to correct themselves on the record multiple times, and here we are. She's putting a gag order. Now, this gag order is going to apply to both the prosecution and the defense, but do you see how she has to put it in there like, um, we've got to prevent the defense counsel from making these statements. The Commonwealth seeks to prevent defense counsel from making these statements and from revealing protected information to the public through the media. In June 2023, the Commonwealth filed a similar motion to prohibit extrajudicial prejudicial statements of counsel in compliance with the Massachusetts Rule of Professional Conduct. The court denied this motion. So why now? Concluding that no trial date had been set and that this minimized the likelihood that extrajudicial statements would materially prejudice the proceedings. In so ruling, however, the court emphasized that all counsel are bound to comply with the standards for attorneys with respect to extrajudicial statements. The court also made clear that neither party should interpret this decision as precluding a future court order limiting counsel statements. At the March 4th hearing of this year on the Commonwealth's motion for sanctions under Massar Crim P 48, the Commonwealth reasserted its request for a so-called gag order, arguing that the defense counsel have violated Massar of professional conduct, the rules of professional conduct, by making extrajudicial statements that defense counsel reasonably should know will have a substantial likelihood of materially prejudicing the proceedings in the matter and have put protected information into the public domain in support of the oral motion. The Commonwealth asserted that the defense lawyers have a history of making extrajudicial statements that may prejudice the proceedings. It also submitted audio clips from an interview conducted by Boston Magazine reporter Gretchen Voss of the defendant and attorney Jackson at the Omni Seaport Hotel on July 13th, 2023, and cited to a recent interview aired on February 17th, 2025, that the defendant and attorney Jackson gave to Fox 25 News. And we've got two footnotes here. Although this interview was conducted on July 13th, 2023, the Commonwealth only recently obtained the audio and shared it with a court. In this other hearing that they referenced, at the hearing on this motion, Prosecutor Brennan also stated that Attorney Yannetti appeared on Court TV falsely representing the subject of the federal investigation. In fact, Court TV played a clip of statements Attorney Yannetti made on a Zoom hearing in court. Thus, contrary to the Commonwealth's representation, the statements were not extrajudicial and thus are not considered for this motion. So we already read through the motion to correct and and all that, how he misrepresented the Zoom hearing as a court TV interview or whatnot. So she's recognizing that that's not going to be recognized in this hearing. His misrepresentation, she's not considering those statements because they were not extrajudicial. So based on these interviews and defense counsel's consistent publicly reported interactions with reporters and bloggers, she's got to throw in throughout, Turtle Boy, shout out to Turtle Boy, throughout the first trial, the court agrees with the Commonwealth that an order limiting extrajudicial statements of counsel is both appropriate and necessary to ensure a fair trial and impartial trial, and finds that no reasonable, less restrictive alternative to the order is available. During the Voss interview, the defendant, with Attorney Jackson seated at her side, this is all under a protected order. So Bev, who is mad at the defense for putting something out that's under a protective order, just filed something with information that's in a protective order. I just want you to remember this. There's so much hypocrisy going on in the Commonwealth that it makes your head want to explode. So during the Voss interview, the defendant, with Attorney Jackson seated at her side, told the reporter about witness testimony from the defendant's sealed grand jury proceedings. Specifically, while discussing Voss's recent visit to the Waterfall Bar and Grill, the defendant stated that the bartender who works there had testified before the grand jury. After further conversation, the defendant then told Voss the substance of the witness's testimony before the grand jury. The requirement that grand jury proceedings remain secret is deeply rooted in the common law of the Commonwealth. They didn't share it. They didn't let her take pictures of it and put it on social media for all to see. They're allowed to talk about what happened in the grand jury proceedings. They didn't show her the testimony transcripts. That would be something different if she allowed them to see them and take pictures and publish them. That would be against the law. But talking about them, not against the law. The requirement that the grand jury proceedings remain secret is deeply rooted in the common law of the Commonwealth. In order to protect the process from extraneous influences, protect influences from notoriety and disgrace, protect witnesses from intimidation and subornation, and encourage the free and full disclosure of information concerning commission of a crime. I don't know what she's mad about. Nothing was, I don't know, whatever. She's just a rude old bat. That's what that's what Judge Conodi is. Back to the document. Rule 5D of the Massachusetts Rules of Criminal Procedure ensures the secrecy of the proceedings and governs disclosures. It specifically prohibits anyone other than a person performing an official function in relation to the grand jury from disclosing matters occurring before the grand jury except in the performance of his or her official duties or when specifically directed to do so by the court. Although Attorney Jackson did not himself disclose information about the grand jury proceedings to the reporter, he had two opportunities to intervene to prevent his client from disclosing such information. Instead, he sat idly by while his client disclosed to a reporter the testimony given in grand jury proceedings. Was he supposed to say, "Don't talk about that"? I mean, does he have to? The rules of professional procedure only apply to Alan Jackson. So Karen Reed can talk about the grand jury findings. There's no reason not to, especially if it was off the record. And this, I believe this was, and that's why it's protected. But Judge Bev just put it all out there for the world to read. Additionally, during the interviews with both Voss and Fox 25 News, Attorney Jackson disparaged witnesses in the matter. Oh no, the witnesses that aren't credible? You mean those? Those witnesses? Come on. In the Voss interview, he specifically referred to two witnesses as liars. Statements commenting on the character, credibility, or reputation of the witnesses are more likely than not to have a material prejudicial effect on the proceedings. And we've got a footnote here. The court also notes that Attorney Jackson had a conversation with Voss at Omni Seaport Hotel during which he revealed information that had been turned over by the Commonwealth in discovery but not yet made public. Oh no. In that discussion, Attorney Jackson acknowledged to the reporter that he was not permitted to disclose the information that he received in discovery and told her that she should not publicly disseminate the information until it was put in the court motion. But he's being a source. He's a leak. He's I don't know. I can't. Like if you're a whistleblower for corruption, you've got some other protections that should be enforced with reporters. Although I don't know if I'm sure attorneys can be whistleblowers, but I don't know if they can be sources for people in Massachusetts. In the subsequent Fox 25 interview, Attorney Jackson claimed that one, although individuals involved in the case know what really happened, they are not talking, and that two, witnesses in the Albert home the night of January 28th had obtained lawyers for self preservation, which implies that they are not being truthful in their statements to law enforcement about what occurred. They're not. They're not being truthful, Bev. If you didn't notice that in your own courtroom, that you had lying liars who lied on the stand, then what are you doing on the bench, Bev? All of the Commonwealth's witnesses were so not credible. Yet she's saying that because Jackson said they're not credible, that's wrong. Okay. In the decision on the Commonwealth's first motion to prohibit extrajudicial statements, the court stated the defense counsel's statements to the media had at times arguably crossed the line of permissibility under Rule 3.6, but concluded that the risk of prejudice was minimized by the fact that no trial date had been set. With trial now imminent and with the above mentioned examples of improper statements made directly or indirectly by defense counsel, the court is no longer satisfied that the less than restrictive alternative to the order previously given, the reminder to counsel that they are bound by the ethical and procedural rules is sufficient to ensure a fair trial in this matter. The court finds that there is a substantial likelihood that the continued comments about witnesses and evidence in this case by counsel in the future might well taint the jury pool. Therefore, an order restricting such statements is now both appropriate and necessary. For the foregoing reasons, the Commonwealth's motion to impose sanctions pursuant to Mass R. Crim P is denied. The Commonwealth's motion to prohibit extrajudicial statements, you mean their oral motion? They didn't even write it on paper, is allowed, and it is further ordered that none of the lawyers, so both sides, appearing in this case shall release or authorize the release of information about this proceeding that a reasonable person would expect to be disseminated by any means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing potential trial jurors or witnesses in this case. None of the lawyers appearing in this case shall release or authorize the release of information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. And none of the lawyers appearing in this case shall release or authorize the release of protected information in this case, including information subject to a protective order or information protected under the rules of criminal procedure. Lawyers appearing in this case shall remain subject to all the relative provisions of the Massachusetts Rules of Professional Conduct, including Rules 3.6 and 8.4. So there you have it. Bitchy Bev being Bev, just, doing Bev, doing the things that Bev does. She helps the Commonwealth prosecute their case, and she tries to handicap the defense, string things out just so Karen Reed is bled of her money, her finances, and I think she likes to cause drama in her courtroom, even though she likes to pretend that AJ and Gennady come in bringing the drama. She is the drama with her huffing and puffing into the mic and acting like God Almighty herself. I really cannot stand Bev. Impeach Bev, please. State of Massachusetts, impeach her. Somebody help. We need help in this case because Bev is awful, in my opinion. What do you guys think of Auntie Bev? What do you think of Hank Brennan's correcting the record? I'd like to know about that. And of course, what do you think about Bev denying Bederow to the T? I think she is setting herself up for making herself famous and notorious, but not in a good way. I think all these bad decisions are going to come and bite her in the butt. I think she's ruling out of emotion, and she doesn't like being made a fool of in her courtroom. And she is the dumbest one there. And that's including out of her and Lolly. She's the dumbest one in the room, especially when it comes to law. And somehow she became a judge, and she is sitting in that position and getting out-lawyered by all of the defense team, and she doesn't like it, and she can't handle another one doing it to her. So I think that's why she denied Bederow. But again, constitutional rights, man. It is Karen's constitutional right to have an attorney of her choice. It's her right to have certain expert witnesses. It's her right not to be bamboozled by the prosecution by throwing in a dog trainer instead of a medical expert to opine on medical injuries. Like, it's her right to have a fair trial, and every ruling lately, because she didn't always used to be like this, her corruption wasn't this blatant in trial one. Trial two, gloves are off, man, and her corruption is showing, and I think this is all going to come back and bite her in the ass at some point. I really do, and I hope it does. What do you guys think? Let me know in the comments below, and I will see you guys in the next one. Take care. Bye now.